Hey, this is Mike Dirksen from Proactive, and you're listening to the Building Byte podcast. Tune in as we spotlight our guest, Tracy Sachs, president at Sachs, Dornberger & Vita, or SDV Law. Our episode is focused on better navigating the claims process through a legal lens. For more information on this episode and others, please check out the Building Byte at www.buildwithproactive.com.
Welcome to the Building Byte podcast, the podcast for construction contractors, owners, and insurance professionals, where you'll hear from the experts about key topics that can help you be successful. I'm Chris Epps, a senior director with Proactive, and I'm joined here with my co-host Mike Dirksen, our senior consultant of innovation and content solutions. Our guest today, a leader in insurance law and coverage, is Tracy Sachs. Tracy is the president and founding member of SDV Law. Tracy, how are you this afternoon?
I'm good, thank you.
Fantastic. Mike, how about yourself?
Doing great, Chris. Really excited to have Tracy on the show and get this going.
Awesome. Well, let's get right to it. Tracy, thank you again for joining our show today. Always a pleasure to connect with you. Before we dive into our main topic, I was wondering if maybe you could give our audience members a little bit about your background and yourself and your career.
Sure. First, just thank you for inviting me on. It's been a pleasure to work with you guys and know you guys, and I look forward to participating in this podcast. You've got a great thing going here. So just about myself, I've been practicing law nearly 40 years now, which is a little surprise to me sometimes. But I started out essentially, I really just wanted to be a trial lawyer of any sort or type and just try cases. And in my early career, I tried all sorts of cases. I tried a murder case, I tried paternity cases, divorce cases, personal injury cases, all sorts of stripes. And then after about 4 years of doing that type of thing and doing quite a few trials, I moved a little bit more toward a commercial litigation practice and trying cases that were more business-oriented, more corporate-oriented. And after a period of doing that, I ended up really almost accidentally falling into the insurance coverage realm. As it's funny, I talked to a lot of other people, not necessarily lawyers, but people in the insurance world, whether it be risk management, brokerage, insurance, forensics, all those things. And often they have the same story. Yeah, I didn't really set out to be in this insurance world, but somehow I found out about it and I like it. Yep. So I'm in the same boat. I had a call from a friend of mine from law school who had by that point taken an in-house counsel position at a major corporation, and they had all these asbestos issues in the late 80s, and they were having fights about the insurance like everybody did and everybody still does on that arena. And he said, you should take a look at this coverage, these insurance coverage issues. And my reaction, I still remember, was, that sounds really boring. But I was wrong. I went and looked at it and said, no, actually, this is the most interesting and exciting stuff I've had the chance to do. And during the late 80s and into the 90s, I evolved my practice that I was doing exclusively insurance coverage on behalf of policyholders. I ended up being co-counsel with some folks who were not there anymore, but were at Anderson, Kill, Olek, and Oshinsky, as it was known then. They asked me to open a Connecticut office for them, which I did. And after a few years, I kind of remembered why it was that I didn't want to be part of a really large firm. And we ended up changing the name on the door and opened up our own practice, which became Sachs, Dornberger & Vita. And that's about 26 years ago. We've grown from a few lawyers to now the point where we'll be 50 lawyers by the end of this year. We practice in California. We have offices located in California, Florida, New Jersey, and Connecticut, but we've always practiced nationally because the nature of the insurance coverage practice, you really, since there aren't often choice of law and choice of venue provisions, you can end up bringing litigation just about everywhere. I think that kind of brings you up to date where I am now.
I love it, Tracy. It doesn't spare anyone, right? Falling into insurance. Doesn't matter if you're on the legal side of it, the carrier side, you just all of a sudden you're like, I'm in insurance and I kind of like it and I'm going to stick it out. Yeah, that next thing you know, it's been years, right? So you're not alone in that regard. Exactly.
That's how I got here.
It's like the number one reason we're all here on the show. So that's been great. But Tracy, so let's jumping into our primary topic today. I want to discuss builder's risk, best practices, common pitfalls, things that you're seeing on the legal side of things. You know, in our first question, while it might seem simple on the surface, it could be pretty complex and really be a differentiator here. So who do you think should best be purchasing the builder's risk coverage, right? Whether that's the owner or the GC. In your opinion, what do you see works best?
So not to be a stereotypical lawyer, but it depends. So let me tell you what it depends on, though. That'll be a little more helpful. I think that when you've got sophisticated risk management and sophisticated brokers, either one can actually do it well. So assuming all things being equal, though, let's talk about the pitfalls and the upside of each of them doing it. What happens is the general contractors tend to have longer term programs. They often have a rolling builder's risk program in which they've worked out really excellent terms. They've got a long-term relationship with the insurer, and they've kind of buttoned up a lot of it, and they keep rolling new projects into it, which ends up with a really good sophisticated program, which is good for both the owner and the general contractor when they're both insured under such a good program. The other side of the coin is that even though the owners aren't as likely to have this rolling program, some do, but if they're really constantly developing and building. But even when they don't, the problem that the general contractor has is if you're going to buy the business interruption or the delay in startup coverage, the business interruption valuations aren't accessible to the general contractor. That is proprietary information, typically with the owner. And so you end up with this difficult problem that the general contractor could do a good job on the general terms, but on the business interruption piece, the owner is better off. I actually recommend something I haven't really seen too often, which is that they really work together jointly through a sophisticated broker. And maybe this way the information can be shared with the broker about the business interruption values without having to tell the general contractor the information they don't want to. And this way they can get a better product out of it. I also worry sometimes I've seen less sophisticated owners take the position that they worry a little less about the business, the builder's risk piece, figuring they've got contractual rights against the general contractor for most of those problems. Well, that causes two different issues. One, you've got the GL coverage very commonly, particularly in wrap-up policies, is going to have course of construction exclusions, which will leave the general contractor in an awkward spot and therefore kind of creating litigation between the two. Getting a good builder's risk policy, I think as we'll talk about later, does result in less litigation and less disputes between general contractor owner. And when that happens, the project moves along more smoothly and more quickly and more efficiently.
Excellent points. Yeah, and it's important to note, right, there's many different layers of the relationship that's happening here, right? Whether it's just that frequency, right? You mentioned sometimes the owners and the GCs, they work together so frequently that there's a really good working relationship there, but there's that contractual relationship as well on a case-by-case basis. So when it comes to the claim responsibilities then, you know, if our listeners are tuning in right now, how do they best prepare for that, right? Fulfilling their obligations and increasing the likelihood of recovery, making sure that they're not running into any legal snares or anything like that?
Well, I think that it's much better right at the beginning, if a claim is going to occur and even preparing for the idea that a claim may occur, that everybody has identified who is on their team, who you're working with, and that you stop, take a breath, figure out, and try to figure out a way to work jointly. Let's just take a big picture view of things. A builder's risk policy is a first-party coverage. It's always good to go back to fundamentals. This is not a third-party liability coverage like your GL, where you could have overlapping coverage. But remember, a general liability policy requires a claim against you. A first-party policy does not require a claim against you. And once you have a claim against you, you're opening up a whole can of worms and a layer of issues that make it more difficult to work together jointly. And so if you can either agree to work together right at the beginning, or at least defer whatever issues that might be in dispute until you've actually worked jointly on the first-party claim against the insurer, and then whatever's left over you've reserved for later dispute between you, you're going to end up with a better claims process. I would also say right at the outset, you should treat the claim, once something has happened on the construction site during the course of construction, as though it were a new project. You should get new codes in place so that you're tracking everything for this new project. Your scheduling should reflect that you've got a new schedule as of that date. Very important also to have kept your schedules up to date so that you can show where you would have been compared to where you are, and now under the new project, the time that's going to be involved in doing things, and you might end up doing them differently, not just doing them later.
Great advice there, Tracy. Although we, in our business, we frequently see issues stemming from misaligned coverages and gaps in coverage, especially relative to contracts on projects, which, as you know, can lead to failure to meet policy requirements in a lot of instances, especially if you have poor documentation. So how do you help members in the industry avoid those type problems and those pitfalls? And if they find themselves in this situation, like we commonly see, what's kind of the best path forward? What's step one to get out of trouble there?
Well, the first thing is to really pay closer attention to the risk transfer provisions of the contract between the owner and the general contractor and the general contractor and the subcontractors. If you're dealing with an AIA contract, it's going to be that section 11, 11.3 and throughout that area where they're talking about who has the responsibility to buy the builder's risk policy, what claims are being waived by having the obligation to buy it, and what claims are being waived when you buy the business interruption piece. It's that form is very specific, and I think a lot of the GCs and owners don't pay enough attention to that, don't fully understand that the entire scheme, including in the AIA provisions or any other general contract, are taking into account that the idea that they've agreed together to turn this risk over to a third party for both of them, and that all claims between them should be waived. And sometimes, because the owner and general contractor are more comfortable in the construction dispute realm than they are in the insurance coverage realm, they start to fight that, not recognizing that was already waived and that their sole remedy might be exclusively to go after the builder's risk coverage. So look a little bit more closely at the typical terms. Look at what it says about what needs to be purchased and the coverage. And the GC should understand that even when the owner buys the coverage, they probably should negotiate that they get some input into the coverage that is purchased, because it may be their loss. It's also, to the extent it's the owner's loss, the owner, to the extent they don't have coverage under the builder's risk program, is going to pursue the general contractor. The broader the coverage that they're required to buy as the owner, the broader is the waiver of the claim that comes back against the general contractor. So I guess it's really just one piece of advice. Read your contract very closely, negotiate it up front, think about it in terms of think about the contract as though the disaster has already occurred. And then would this work for me? If it doesn't, modify it right up front. The second part of it is to make sure that your builder's risk coverage itself, that you look at the policy and it mirrors the terms of the contract, that it has sufficient coverage, and that you're happy with that. Some of the problem is if you don't have a master rolling builder's risk program, sometimes you're binding that policy and you don't actually see the terms for a period of time. That is kind of a problem. And what happens is the rush of getting things done, you've got a binder on a policy, but you don't have a policy and you're moving forward. I don't like that idea. If you can do something about that, I would try to do it up front.
It's a fantastic advice for both parties, and potentially impacting coverage for anybody who could bring one of those claims. We all know it's impossible to eliminate claims, and sometimes it seems the harder you try, the more difficult that gets. The problem seems to grow. But in the event of a claim, how would you advise an insured to proceed, or their common pitfalls they should be looking out for as they enter that process, assuming they haven't done as you've advised and kind of already put themselves in that shoes before, in that situation before it happens?
Yeah. And I think I've sort of prefaced or previewed some of the answers to that question with the previous comments, but I would say I refer to it as avoiding the finger pointing. For the most part, when you're talking about a builder's risk policy, I would say the most common troublesome exclusion that you're going to have to deal with is construction defect or faulty workmanship exclusions that are in the policy. Let me just sort of take a step back and then roll back into that. It's important. I mentioned earlier, builder's risk coverage is first-party coverage. And not only is it first-party coverage, meaning you don't have to show it's anybody's fault and you don't have to have a claim against you. It takes it one step further. It's also referred to as all-risk coverage. And what it means is that since we've gone away from, it's very uncommon now to see the old specified perils form, which said only the following things are covered. Now it says all risk of physical damage are covered. That being the case, it immediately, as long as it happened at the project site during the course of the construction, and there's physical damage or risk of physical damage, you're going to have you're going to have an avenue into the policy. From that point forward, right at the outset, it all turns to the exclusions. And so since this is about building, it's going to be the faulty workmanship exclusion that becomes the most important. And the faulty workmanship right now, the most common American form of this is sort of the resulting loss type of exception coverage. So let me explain this. So what it says is that everything is covered during the policy period, which is the course of construction, at the particular geography, which is the project site, except if there is faulty workmanship. And then exception to that exclusion for faulty workmanship is it does cover all resulting loss, not the faulty workmanship itself. That's the American format. There is also what we refer to as the London Engineering Group form, which is becoming a little bit more common in the U.S. and something that if you can get your broker to buy you that coverage, I think it's better as long as it's leg 2 or leg 3. We're not going to have time for all the details here, but just you can make a note. Anybody can call me if they want. But what I mean by leg 2 and leg 3, but it's much easier, less litigious way of having to deal with this issue about whether or not the damage results. I'll give an example just about this resulting loss. And the idea is, let's say, for instance, we had a similar example. Let's say false work for a bridge. The whole thing is built out, and they bought ungalvanized bolts that cost $1, and they snap, and the entire bridge collapses. And they say, well, that's due to faulty workmanship is what the insurer's response is. We're not paying for the collapse of the bridge. The response is, no, the faulty workmanship was the $1 for the bolts. The rest of it is resulting loss. Don't pay us the $1. You owe us the rest. That's sort of the debate that happens there. Even that debate of deciding what's the law, what's the faulty workmanship, and what is the resulting loss, you don't have to worry about that under the London Engineering Group forms, at least leg 2 and leg 3. And so that ends up being litigated a lot more, which is not good. Anything that gets litigated is not good for getting things resolved. But having said all that, that's all kind of the background. Now, what do you do to avoid these type of coverage disputes? Well, don't make it worse by, as we've mentioned before, when the claim occurs, don't start sending emails blaming this subcontractor or blaming the owner or blaming the architect or the owner blaming everybody. All of those emails will not help you with your coverage. Those are all going to be discoverable by the insurance company, and they're going to pull them out and say, hey, this shows that the exclusion applies because you guys alleged it was faulty work. Now, those early finger pointing are often untrue, but it's definitely going to hurt you down the road when they say, hey, I don't know, we're not so sure anymore. Now we have all this evidence that you guys thought it was the faulty work of the architect or the one of the subcontractors that caused this issue. So rule 1, don't start the finger pointing. Stop, call a truce with everybody, agree to work together, put together the no-fault claim that it doesn't matter whose fault it is with the insurance company, and don't create fault when there is none. You can always reserve all those issues if you don't have coverage or there's limit to the coverage. Second, I would say take the claim and divide it into 2 pieces. Think about this as pre-loss and post-loss. Pre-loss, make sure that you've looked over your coverage with the post-loss in mind, that you've bought the right coverage, you've got sufficient limits, you've got limited exclusions or better exclusions. Choose if you can, and a lot of contractors and owners who have enough leverage or sophistication have been able to choose the adjustment team. And I think, does that happen? That must happen for you guys, that you might actually technically be working for the insurance company post-loss on the adjustment, but you were chosen up front by the policyholder because they felt like you would be fair and you do a good job and you've come to know their business, which speeds up how the claim. So I would always recommend select somebody who is acceptable to the insurance company, of course, but that you get to choose who the adjustment team is, especially if you're unhappy, and some other companies will go unnamed for the purpose of this particular broadcast. Some of my clients have had very bad experience with some other adjustment companies who were hired on behalf of the insurers, and if they have the opportunity to choose someone who they think is at least going to try to be neutral and fair and just put an objective adjustment out, that's very helpful. So I already mentioned before, I'll just say again, treat it as a new project, code it as such, think about it that way, do the scheduling that way. It's sort of suddenly there might be a whole different way you're going to have to build this. I'll give an example. We had a case many years ago, I think it was Hurricane Wilma down in Florida, and they were in the middle of the construction. The hurricane came through, and they had bought specialized concrete forms that they were able to use, and the advantage of them was you didn't have all of this stanchions and scaffolding on the floor that you were building out to hold up the one above it, because these custom forms left lots of room open and allowed the trades to get in there even while you're waiting for the next floor to be safe to work on. And so it blew all these custom forms out. It would have taken 6 or 8 months to get them from Europe to redo it that way. They had to actually start a different way. And now the trades are backed up differently. They're all being scheduled differently. It takes longer. There's a loss of productivity because it's a new way of doing this. And so there is damage to the project delivery in that way. And therefore, you need to document that and show that this differential in the way you did it before and the way you do it now cost you more money and took you more time. And so that if you think about it as two separate projects, the new project is done one way, the old project was done another, it kind of will crystallize your thinking about how you move forward with that.
Mm-hmm.
I think I already mentioned this at my last kind of comment I made a note of, which is to say, get the money first from the first party no-fault coverage, and reserve your claims against each other for later. And this way, who knows, maybe you get it resolved with the insurance company and you don't have to bring those claims later.
Yeah. One thing that jumps out to me with this, Tracy, a lot of this is from experience, right? And you've seen a lot of these things, and hopefully the GCs, you don't have teams that have seen repeat claims too often, because that means that something's going wrong. You know, if we're looking at the analogy of a car crash, we got to look back at where the tire marks start, not the crash each time. But to that degree, there's experience and there's value in that experience of how to set this up, how to approach it quickly and the right way the first time, like you're talking about. So one of the topics that's been on the show is we've talked a lot about the labor shortage, how that's coming to the industry, how there's a large workforce exodus pending on the way, you know, as I've heard it now referred to as the bubble, that it's going to prolong and then there's going to be a gap there. So as some of those more senior executives leave, who maybe have seen more of these, have prepared for these, and we're going to backfill with younger professionals who maybe haven't had that level of experience. I mean, do you think this is going to be a major issue? How would you advise towards making sure that we mitigate that risk?
So a couple of things. I think you're right, and other guests who you say may have commented on this, that I think we saw this already. After the financial crisis in 2008, people did not hire. And then what happened was, as the older folks retired out, and there was a gap of, say, 7 or 8 years before new people were coming along, and then suddenly the economy picks up and it's booming, and you've got the same GCs running many more jobs with less experience. You're going to have younger and less experienced people on more sophisticated jobs than you used to have. I'm not saying that necessarily causes some sort of problem, but the odds start to increase, and I think you see an increase in problems in that regard. I would say the other part of it is also true that in the claims world and the insurance world, a lack of sophistication makes for more litigation. That when things aren't handled well, there tends to be more times that people come to us I've often joked that in some ways I feel like when we're looking at policies and claims and problems, it's like astronomy. We look out at the stars. What we're seeing happened a long time ago. By the time it went through this entire process and got to my desk, this is kind of old news. But what we end up seeing is that we get more stuff comes to us when the risk management on the policyholder side and the teams on the insurance company side are less sophisticated. The more sophisticated they are, actually, the more times they work it out, not the more times they fight. So that also, I think, what happens is we're going to see that the cost of the claims are going to rise, which also puts extra pressure on the insurance company to resist more. That to some extent, when they set up their business interruption values on the projects, they may not have taken into account the idea that labor shortages and maybe the bidding up of scarce labor like electricians and others is going to increase the cost and increase the length of time it takes to get things done. And that, although the policy doesn't ever say that somehow the coverage you get is limited by, what you told us on the business interruption values, it always feels to me like the claims people treat it that way. If you understated what your business interruption values are and they took the premiums on that basis, they're much more eager to tell you, hey, you don't have quite that much coverage, even though that's not what the policy says. It just causes difficulty in the relationship. So there's going to be underestimates in that regard. There's going to be increased cost because of a shortage of labor. There's going to be a slowdown in the time it takes to get going, which is a greater business interruption. All of these things, unfortunately, do not bode well on the claims end of things. You're going to just see more claims, and then they're going to be thought about more, and then they're going to be surprisingly more expensive than anybody expected.
I guess, Tracy, speaking of seeing more claims, maybe taking a different look at a different aspect of the industry, as somebody who advises and represents insureds, are you seeing a backlog in the current legal system, maybe stemming from COVID and increased in work coming out of COVID? Do you think that's going to lend itself to maybe leveraging ADR or other avenues to settling claims prior to litigation?
Yes to all of those things. So let's take it kind of one by one. I think the courts, even before COVID, were already slow in getting to resolution of matters. It's always been difficult to get a case that needs to be tried to a trial. Now, having said that, I think the statistics are something like 97 or 98% of civil matters actually don't go to a full trial even after a suit is brought. So, but many of them have the suit pending, and through an ADR process, either courtside mediation or private mediation, there is a resolution that takes place. I think that, however, it's always seemed to me, and I say this to clients, the best way to get a case settled is to be totally prepared to try it. The best way to end up having a case be tried is to not be prepared to try it. That's just the way it works, and you can figure out what the dynamic might be for yourselves. But the issue there is that the pressure of an upcoming trial tends to create reasonable settlements earlier. The court backlog that slows down the time it takes you to be exposed for a trial date means that there can be longer time spent in the litigation process before the settlement happens. And I've got to say this, this is some sort of condemnation of the legal profession. It really isn't intended to be, but there's no doubt in my mind that if you take a trial that's supposed to come up in July and you push it back to January, the lawyers don't feel comfortable not continuing to work on the case and making sure they're fully prepared, meaning that they could have tried that case in July, but they're going to continue to work on it, which means the cost of the litigation also went up. The expense to the client on both sides went up. All the more reason why it should be settled. And people should stop being concerned about the trial date creating the settlements. Try to have your settlements early, figure out the case early, evaluate it totally at the outset before you even get started, and see if you can bring it to an early resolution is the solution for all that. We found more and more that we use ADR, which is a really important and strong tool for the type of policyholder insurance coverage work that we do. And we often will try to bring the things to a head with the insurance company through correspondence, very sophisticated correspondence, maybe even more sophisticated than briefing that would go on at a court, because we know our insurer counterparts understand these issues better than the judges do. And then, with or without a suit pending, try to get to meetings, and if that doesn't succeed, get to a formal mediation, even without suit pending. We've had increasing success of getting an early resolution, but I think it's also in part because we have the credibility that they know that if we need to try the case, we will. I don't have any fear, as I've heard people say, well, I don't want to be the first one to ask for, a settlement because I think it shows that we're weak. I don't believe that. What shows you're weak is that you're afraid to actually ask. I think if you've got your case evaluated and you know what it's worth and you know the range and you've got a good lawyer on the other side and a sophisticated insurance company on the other side, the evaluation should overlap and you should find a place that you can settle the case and save everybody the legal fees of moving forward on that case. I hope that was the answer to your question.
It was. That was a great answer, and I think holds true with kind of what we've seen. I can't tell you how many times we've gone into a mediation and seen, both parties kind of come in maybe treating it as fact-finding or feeling out the claim, and and find some common ground. And that's the intent of mediation. But a lot of times, even if they come in at different opposite sides of the spectrum, you figure out what their exposures are there, and you learn a lot, and maybe it does entice you to or provide some leverage to settle.
Yeah, the bigger cases and the more sophisticated issues, they don't necessarily settle with a single day of mediation. Yeah. And you kind of touched on something which is sort of a fact-finding process. We've had sort of what I would call technical mediations, which really aren't dominated by the lawyers, and sometimes the lawyers aren't even there, where either the adjustment teams or the respective experts, whether they be schedulers or quantification experts or construction or building experts, that they meet together and they see to what extent they can come to some sort, at least limit the parameters around which there's still a dispute, which makes it easier then for the legal people to sort of step in and say, okay, we can take that, quantify it, and talk about the range of settlement and get this thing done. But I like those ideas of using the ADR process not merely for negotiation, but sometime for limiting or narrowing the scope of the dispute between the parties.
Yeah. Well, Tracy, this has been a really informative conversation. We love to have you on the show. As we're starting to move towards the end here, starting to wrap things up, one thing we do like to do is give our listeners an action item, right? So if you were, whether you're the owner or a GC listening today or a carrier listening to the conversation, but if you're looking to start making a change, right? If there was something tomorrow saying, okay, I need to get more sophisticated, I need to be on a higher level of expertise here, what would you say would be that number one action item for that?
Well, I've mentioned a few things, but I'll go to one that may not be the foremost one, but is one that I haven't talked about first. I think that right at the beginning, even at the same time that you're starting the project and you're putting together your construction team, put together your claims team. If you're going to have at some point some sort of outside forensic expert, whether it be for quantification, whether it be for scheduling or engineering, identify who that team is, and I would say find a team and keep using the same team, because they'll get used to the way that you as the policyholder work, and they'll get used to where they find the information, who they talk to. Oftentimes, when you've got a disaster that occurs at the site, you're already out of sync. You're already doing things just to catch up. To have your operations people suddenly have to introduce to a new team of folks who don't know anything, don't know how to be more efficient, everything gets stalled, and that doesn't work as well. So that team should make sure that you've got the risk manager or claim person in place internally, that you've got a sophisticated broker who is part of your team and prepared to deal with a claim as it comes along, that your forensic team is in place, and defense counsel, if that's appropriate, whether it be the construction dispute or if it's some other type of claim that you might be dealing with, and then a person like myself who is coverage counsel to be part of that whole thing.
Right.
I find that the forensic team and the coverage counsel can end up being sort of a sub-team of their own, where what's going to happen early on is just trying to figure out how to bucket these claims. Forensic teams can be very, very good at this, but they need us to give them the legal advice saying, but here's where the buckets are. Here's how the sub-limits play out. Here's how we get additional coverages. Here's what's excluded, so that we're making sure that we understand that things that might belong in more than one bucket are put together in a way that is most advantaged to trying to find coverage for the losses. But having that team in place in advance is going to be a big help to you. And think about it this way. If it's a natural disaster that is the cause of the loss, that natural disaster didn't happen to just you. You're not the only company out there scrambling, looking for experts and lawyers and claims people and getting their attention. Having that already in place is a tremendous help. I would also suggest, this is a little bit beyond what we're talking about, but also the folks who do disaster recovery stuff. You may want to make sure that you've got a contact, you have a team, maybe even have them under contract, so that when a natural disaster occurs, that you're not the one left out in the cold because you can't find somebody who isn't already busy with this major natural disaster. So that's the major thing. The things I've already mentioned a little bit: avoid the finger pointing, view your contracts and your policies very closely, do a good job buying it, start with a sophisticated broker who gets you good coverage.
And I like that, especially, Tracy, because as we talked about before, talked about, there is going to be a wave of more senior experienced people leaving the industry and, backfilling that. But in this scenario, as you're stating, if you have that team of consultants and experts who have been cohesively working together as a unit, for the insured, even if you have to backfill, there's a system in place, right? You're going to, maybe the risk manager changes, it's a younger, less experienced risk manager, but there's a system in place with trusted advisors, and it's a known commodity. So doing that actually will help support you even through that time, should you need to make adjustments to your personnel.
Yeah, and I would add to that, I emphasize more to the policyholder side, but the policyholder also should be interested in having a long-term relationship with their insurer, that they know that adjustment team on that side. And again, if you can, select who the insurance company's outside adjustment team is that you've had a chance to work with before or you have some trust in. It's just going to make things move much better.
We can certainly attest to that on our end. It's the projects where we've already got working relationships. You know what to expect going in, and you're right. It's the areas where you have sophisticated risk managers and sophisticated brokers representing you go much smoother when everybody's on the same page and the same sheet of music just starting out. But extending that to an entire adjustment team just seems to make a lot of sense there. In the event, you do have something that happens and you end up needing to make a claim. So before we let you go, Tracy, we like to hit our guests with a few rapid-fire questions. And one thing we like to ask is, what gets you energized about your work at SDV and the construction industry, and what gets you out of bed in the morning?
Well, I'm excited about a lot of different pieces. One of it is the fact that I now have a firm that I love being with. I've got a great group of lawyers. We're almost 50 lawyers now. We all do exactly the same thing. It's all insurance coverage work on behalf of policyholders. And, today's topic is really about the construction industry. And somewhere starting in the 90s, we ended up starting to do work for general contractors, owners, architects, and design people, and some subcontractors too. And it used to be when I was doing solely environmental or asbestos or product liability or even patented copyright coverage issues, there was often that we'd see a company and they never had a problem with insurance coverage again. It was a unique thing. It was a Superfund site. It was some particular class action product liability problem. And after they were done, I didn't really work with them again. What happens with the construction industry, sort of to my benefit, maybe not to theirs, is they have repeated problems with insurance coverage. It happens every day. There's something about the nature of the way that they work as owner and general and all these subcontractors that results in a lot more litigation and therefore a lot more insurance issues and a lot more insurance disputes. So that without ever intending to be so, probably over 60% of our revenue is associated in one way, shape, or form with real estate or construction work for insurance coverage. Now, we're not construction lawyers. We don't defend or bring construction cases, just the insurance coverage. And what's fun about the firm is that since we're all working on the same thing, it's a much more collegial atmosphere. It's like almost academic. We can talk to everybody about anything. It feels like a much smaller firm because we're all working together, and each team is reconstituted in that way, that we've got senior and junior people who are in new teams all the time, and a lot of cross-fertilization and great ideas. And we end up with great results due to the collaboration we have among ourselves and the natural mentoring and training we have of our young lawyers who become very sophisticated very quickly in this practice. So as one of the leaders of this firm, that really excites me a lot. The second piece I'll say is sort of outside with the clients. We really are so pleased with the loyalty our clients have shown us over the years and the growth of our client base within this construction practice. Coverage practice for construction, I should say. If to my surprise, if we looked around and looked at the ENR, like top 15 or 20, we probably represent 3/4 of those companies. And unlike a lot of the other lawyers that they hire, they've got different lawyers around the country. We typically are their only insurance coverage counsel, and we do everything for them nationally, wherever that comes out. I couldn't be more flattered by the faith they've shown us, and it really keeps me very excited and on our toes to want to make sure that we're still doing the type of work that keeps them coming back to us.
Yeah, it's a lot to be excited about. There's great things there. Tracy, I feel like we've asked you a multitude of questions today. We've ranged a bunch of different topics, but what's something that we didn't ask you that maybe we should have in this scenario? What's something that you were like, I wish I got a chance to say that?
Well, good question. Let me throw out there the idea that one of the things that I keep going back, that we work hand in glove with brokers. We have so many brokers, clients that as we work on their behalf with their insureds, and it's incredible how important it is to have a sophisticated broker. I can't emphasize that enough. And I'll go on to say further than that, what you should be doing is every chance you get, and it's not just limited to builder's risk, this could be all the rest of your coverages. When you go to get another policy, start with the old one, tweak it, always be getting a little better. Try to make sure that you've got a little better coverage, learn from whatever has happened in the past to make it better. I would say even if you've got maybe 10 things you could improve on, each year try to find 1 or 2 or 3 that you can get a little bit of a change, and so that over time you're getting better and better coverage there. I think that's really the main thing. And I think what I've seen some, we represent mostly Fortune 500, Fortune 100 corporations. We represent some smaller companies and some individuals. But I would say that the companies who have grown into the mid-size or bigger, they've done it in one generation. What's happened along the way sometimes is that the broker they started with was perfectly adequate for the small company they were, and they don't always recognize that they've outgrown them, and they need to look and ask them either get that broker to become more sophisticated or add more resources for them, or look around and say, is it time for me to get to a more sophisticated broker?
Those are good points there. And so lastly, one thing I always ask everyone, Tracy, as you notice, this is the Building Bite. That's building insurance technology with the experts. Sometimes it trips people up. What are you taking the bite at today? I know you're in Connecticut. You know, there's the New Haven Pizza. What's the number one spot for you? What's a good spot to eat up there?
Well, I wish you had asked me yesterday. We did have New Haven Pizza. We had a little get-together for one of our people. Today, I took a bite out of the salad, kind of dull, boring. But I was ready for that question because I understood that during the bite, somehow that becomes a question.
Great. Tracy, again, thank you for your time. Thank you for chatting with us today. A lot of great information for a large swath of our audience, and I think people are going to find that very informative. If our listeners want to hook up with you afterwards, because I imagine we touched on a lot of ground, if they got questions, where can they find you?
Well, I'll tell you what, not just to find me, but there are so many resources on our website. You can always find me through the website, but we write white papers of every sort all the time. If you look there are coverage maps for different issues about construction defect, additional insured coverage, indemnification, all sorts of things in there. Builder's risk, lots of articles about that as well, like we're talking about today. So go to sdvlaw.com, and if they want to reach me, you can look at the attorneys there, and you can find our people and find me and find my contact information.
All right. Fantastic. Tracy, thank you again, and look forward to catching up with you again soon, perhaps in person, maybe at a conference or something down the road.
Okay. Well, thank you for having me on. I love your program. I appreciate it.
Thanks, Tracy.
Thank you for listening to The Building Bite. This podcast has been brought to you by Proactive. Check us out on thebuildingbite.com, where you can subscribe to our newsletter and follow us on social media for all future The Building Bite news and updates. You can also find us on your favorite apps, including Apple and Google Podcasts, Spotify, Stitcher, TuneIn, and Amazon. If you have ideas for episode topics that we should cover on the show, or you know somebody who would be a perfect guest, let us know at connect@thebuildingbite.com.